You're listening to the Quint's podcast.
Forests, regarded both as safeguards of biodiversity as well as rich reserves of valuable resources, are often subject to unique laws and policies. Since the colonial period, India has witnessed a continued conflict between indigenous forest-dwelling populations and large resource extraction drives. For Adivasi communities, the forests and their land, beyond being their sources of livelihood, are also at the heart of their cultural practices, beliefs, and identities. On the other hand, resource extraction from these very forests are seen to be critical for the country's economic development by some groups. In this context, how do forest-dwelling populations defend their rights over their land and resources? From the case of the Vedanta Mining Company in Odisha to the uranium mines of Nalgonda, what mechanisms exist to help Adivasis and forest-dwelling communities to secure their rights over their land? In this episode of Land of a Billion, we look at the various aspects of a landmark legislation, the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006. We'll simply refer to it as the Forest Rights Act, or the FRA, and we'll delve deeper into the role it's played in ensuring inclusive land rights. Welcome to the Quint's fortnightly podcast, Land of a Billion. This podcast is produced in association with the Property Rights Research Consortium, or PRRC, which is supported by Omidyar Network India, an investment firm focused on social impact. PRRC is a network of leading think tanks and research organizations working to collaborate and drive policy action in the field of land, housing, and property rights in India. My guest today is Geetanjoy Sahu, who is Associate Professor at the Center for Science, Technology and Society at the Tata Institute of Social Sciences in Mumbai. Thank you so much for joining us, Professor.
Thank you very much. Thank you.
So, the goal of our podcast is to understand what it takes to secure land rights for a billion. To help understand this and also to set the context for this episode, could you tell us a bit about the various challenges that the scheduled tribe communities face when it comes to accessing secure property rights and perhaps how this has changed over time?
The most formidable challenge tribal communities face in the country has been their right over land and forest resources. Though tribals constitute 9% of total population in the country and live in the most resourceful areas in the country, however, their rights over land and forests have always been under threat. Threat to their land and forest rights began during the colonial period and continued in the post-colonial period. It was during the colonial period, the colonial authorities introduced a series of rules and regulations to serve their interest, but it alienated millions of tribals who were the original inhabitants of this country. The process began during colonial period, as I said, with the enactment of various legal instruments, including the Indian Forest Act of 1927, which took over the land and forest resources of the tribal communities in the country. And it continued in the post-independence period. One expected in the post-independence period, the modern state will correct that historical injustice that was done to tribal communities. Instead of legalizing their rights, the independent India, the state and its machinery, instead of legalizing their rights, reinforced the colonial rules and regulations, where the state justified the control over forest and lands in the name of larger public interest. However, in the early 80s, the response of state towards tribal land and resources started changing, though in an incremental way. It began with the National Forest Policy of 1988. For the first time in the National Forest Policy of 1988, the government of India recognized forest is not just about timber or for revenue generation, but also recognizing the rights of tribal communities and their livelihood. And then subsequently, you had other policy as well as legislations in the country, like Joint Forest Management of 1990, which again recognized the role and importance of community in the forest management, and also how benefits can be shared with local community when they are involved in forest management. followed by Panchayat Raj institutions, which the government of India introduced in 1992 with the 73rd Constitutional Amendment, recognized the role and responsibility of Panchayat Raj institutions in local governance. And the same Panchayat Raj institutions subsequently were extended to scheduled areas with the enactment of Panchayat's Extension to Scheduled Areas Act of 1996, which for the first time recognized the ownership rights of local community over minor forest produce and also emphasized restoration of tribal land rights in the scheduled areas.
Right, and just to clarify to our listeners, the fifth and sixth scheduled areas refers to regions with large tribal populations, where the government is responsible for protecting the cultural and economic interests of scheduled tribes in these parts, as specified under the fifth and sixth schedules of the Constitution.
And then today we have a Forest Rights Act, which recognizes the legal rights of forest dwelling communities over land and forests.
Right, right. I like how you've laid down the historical trajectory of the various laws that have structured Adivasis and other forest dwelling communities' access to secure land rights. Something that struck out to me from your response was the aspect about historical injustice. And that's something that's also mentioned in the preamble of the FRA itself. Can we delve a little deeper into this aspect of the law?
The preamble says it is an act to undo the historical injustice that was done both during colonial and in the post-colonial period. That means in the post-colonial period, the policies and programs that state introduced in tribal regions, in forest areas, also violated the rights of forest dwelling communities. They fail to recognize, they fail to record, they fail to resettle people as per the procedure laid down under the law. Because in the Indian Forest Act, subsequently in the post-independence period, Wildlife Protection Act, many other rules and regulations that the government of India enacted, there is provision to record and settle the rights of people before a particular land is declared as a reserve forest or protected area. That was not done as per the procedure. So injustice was done while taking over forests or diverting forests for non-forest purposes. More importantly, the principles that the government of India followed in the post-independence period, what I say, those three principles of extraction of resources, justifying them in the name of national interest without recording, settling rights of people. Second principle is exclusion of people from forest areas for timber production, for revenue generation, for various development projects. And also exclusion of people in the name of protected areas, wildlife sanctuaries, national parks, tiger reserves. Every year, 1 million people get displaced in the name of development projects, and of which 40% people are tribals. In mining projects, especially, you find 52% of people who are displaced are tribals. Okay. Similarly, in protected areas, today you have more than 700 protected areas in the country, including wildlife sanctuaries, national parks, and tiger reserves. 6 lakh people have been displaced over the years, and majority of them are also tribals. So, extraction of resources, exclusion of people, and centralization of decision-making process. Forget about consent. Even consultation was not done with the people when their rights were taken away or when they were displaced from forest areas in the name of development projects.
And I think this brings us, nicely into the efforts that have been led by Adivasis and forest-dwelling communities. And, one among them is called the Campaign for Survival and Dignity. And they called the Forest Rights Act a, quote, weapon of democracy in the forests, end quote. Do you echo this sentiment?
Right. This is an important act because this act empowers the forest dwelling communities to use, manage, collect minor forest produce, which for several decades they were denied these rights because in the early years of independence, all the states nationalized forest produce, minor forest produce. Okay, thereby bringing conditions, regulations, which prohibited tribals and forest dwelling communities to access with those conditions. Okay. But this act, for the first time, especially section 31C of the act, specifies that forest dwelling communities now have right to own, collect, use, and sell wherever they want to sell, whosoever they want to sell, at whatever price they want to sell, are now with the local community. And you have several examples in Maharashtra, especially if you look at the Vidarbha region in Maharashtra, how people have accepted their rights under Section 31C to own, collect, and sell the minor forest produce. That is one. Second important dimension of this act is that it emphasizes the role of Gram Sabha, that is village assembly. So it specifies that the Gram Sabha is the nodal agency in the process of scrutinization and verification of claims. The process begins at the Gram Sabha level. There is a three-tier process: Gram Sabha level, subdivision level, and at the district level. But the process begins at the Gram Sabha level, where the Gram Sabha, consisting of all the adult members of the village, will decide, verify the claims submitted by their village members. In this process of verification and processing claims, the Forest Rights Committee, which as per the provisions in the law, will be constituted at the Gram Sabha level, where there is no role for any government departments in the Forest Rights Committee. This Forest Rights Committee will consist of members between 10 to 15 members, where the president of the committee should be a tribal member. Two-third members of this committee should be from tribal community. One-third members should be women. So this democratizes the process of decision making, where the most vulnerable communities in rural areas, which who have been denied this right for so long, a period, now have the right to decide and determine the process of claim recognition. Okay. And third important dimension of this act is it is not only about the role of Gram Sabha in scrutinizing and processing claims, but also it has given Gram Sabha the space to decide also the fate of infrastructure projects. Before the FRA, permission to divert forests to non-forest activities required only the consent or approval of the forest bureaucracy and a central level forest appraisal committee. But after FRA coming into picture, especially section 4.1 and 2, emphasize the consent of Gram Sabha is mandatory when you divert forest for non-forest purpose. And more so in case of while declaring protected areas, tiger reserves, section 412 says all the necessary conditions shall be fulfilled before we declare parks and sanctuaries. And the fourth important point of this act, as you said about how it is a democratic weapon, section 5 of this act empowers the Gram Sabha to protect wildlife, animals, biodiversity, also frame rules and regulations to ensure that any adverse impact on the forest can be protected. Okay. This responsibility was discharged by many Gram Sabhas in the country, and we have witnessed those 12 Gram Sabhas in Odisha in case of Vedanta Mining Company, how they exercise their rights to stop the mining company because the Gram Sabha under the Forest Rights Act exercise their rights, saying that this project might affect their livelihood, biodiversity in that area. So that's why it is an important act which gives and recognizes the role of Gram Sabha and empowers them to protect the forest in a sustainable way.
I think this helps us to understand the many dimensions of the Act beyond the mandate that the FRA is supposed to enable a formal recognition of ownership over property. So one of the components within, the framing of the law that was quite contested, is this claim by traditional environmental conservationists that the FRA will lead to the degradation of forest lands. The thing about this framework is that obviously it pits efforts to recognize Adivasi and other forest-dwelling communities' land and livelihood rights against efforts to protect the environment. There's a kind of binary that's created. Can you walk me through this debate to better understand it?
Only a handful of conservationist wildlife groups who are to a great extent driven by Western environmentalism argue that Forest Rights Act will lead to destruction of forests or will lead to disappearance of tigers and wildlife animals. These people or groups are saying that Parliament doesn't have jurisdiction to legislate on land. They say land is a state subject and forest is a concurrent subject, and central government doesn't have the competence to make a law on state subject. If we go by this logic, what wildlife groups are arguing in the court, then many of these laws which have been framed by parliament related to land, including your Forest Conservation Act of 1980, Wildlife Protection Act of 1972, Coastal Regulation Zone Notification of 1991, all these are related to land. And these are the same groups who supported Wildlife Protection Act. These are the same group who supported Forest Conservation Act. Same group supported eco-sensitive zones, Coastal Regulation Zone. Okay, so this is not for the first time Parliament is making a law on land, which is a state subject. Parliament has made several laws related to land, including this Forest Rights Act. So the argument saying Parliament doesn't have competence doesn't stand the larger scrutiny. Even I'm sure the court will look into all those previous rules regulations framed by the Parliament. Okay, so that is one. The constitutional validity of FRA, which has been questioned, is a very, very weak argument by the wildlife groups. Second argument saying FRA will lead to disappearance of tigers, disappearance of forests. There is no correlation between recognition of forest rights and degradation of forests. Take the example of Northeast, where many of the Northeast states have not implemented FRA, except Tripura and to some extent Assam. Okay, the remaining 6 states have not implemented FRA. But if you look at the forest degradation, then you see over the last few decades, if you look at the statistics of Forest Survey of India, you find there is degradation of forest in Northeast, where FRA has not been recognized. Okay, whereas forest cover increase in states, like take the example of say Jharkhand, where forest rights claims have been recognized. And third argument by wildlife groups and many NGOs who are supporting this idea of that coexistence is not possible, that Forest Rights Act is a land grabbing act. Even they had gone to the extent of saying it is a land grabbing act. So what we should not forget that the tribals are the original habitants of this country. So before Wildlife Protection Act came, before Forest Conservation Act came, all these acts which the colonial as well as post-colonial states introduced, they came after the colonial rule which began in mid-19th century. Okay, so what this FR is trying to do, it is trying to recognizing the pre-existing rights which these people were enjoying before the colonial rule started, which the modern state has taken over those lands in the name of larger public interests or projects. So it is not a land grabbing act, rather it is recognizing the pre-existing rights. It is not about land distribution, what India did in 50s and 60s under land reforms, where lands were taken from the landlords and given to landless people. It is recognizing their habitation and cultivation rights in forest land.
Right, yes. And, these debates have possibly also influenced how seriously the FRA is taken. So, for example, we know that, there are recurring tensions at the national level also between the Ministry of Environment, Forest and Climate Change and the Ministry of Tribal Affairs, where the latter is often sidelined. Could you expand on this, how the debate plays out at the political level?
A very, very deliberate as well as conscious decision was taken in the beginning to allow the Minister of Tribal Affairs to draft the law and not the Minister of Environment and Forest because of several conflict of interest. However, over the last 14 years, ever since the act came into picture, we see always there is a constant debate, discussion as well as exchange of letters between Minister of Tribal Affairs and Minister of Environment and Forest. It is unfortunate within the same regime, political regime, two important ministers are not able to work and consult with each other. There are many occasions where Ministry of Environment and Forest issued letters, also notifications without consultation with the Minister of Tribal Affairs. Whether it is the rights of tribals in protected areas, whether it is plantation activities in the recognized community forest areas, very often we have seen the Minister of Tribal Affairs has been sidelined. Recently, both Minister of Tribal Affairs, Mr. Arjun Munda, as well as Minister of Environment Forest, Prakash Javadekar, signing a joint letter saying that there will be efforts to ensure that the rights of communities are protected when forest policies and programs are implemented. So this is a welcome, decision, and one hopes they will, recognize the potential of Forest Rights Act as well as the challenges that the Minister of Environment Forest will face when they divert forests without the consultation of the forest dwellers, because it will lead to litigations, and we have witnessed in the past decade how non-recognition of rights has contributed to various types of litigations in the country. Many projects have been stalled because they have been enforced or they have been cleared without the consent of tribals.
And evidence at the national level also establishes that the FRA has been poorly implemented. Where do some of the specific shortcomings lie?
If you look at the Ministry of Tribal Affairs database, what we find that after 13 years of implementation of Forest Rights Act, both individual forest rights and community forest rights, there are 19 lakhs of individual forest rights recognized so far, and there are around 76,000 community forest rights recognized across the country. But if you look at the reports which are available in public domain by various renowned institutes, where these studies have pointed out the bare minimum potential of Forest Rights Act is to recognize 40 million hectares of forests for the forest dwelling communities in the country. 40 million hectares of forests. But after 13 years of implementation, only 5 million hectares of forest has been recognized in the country, both for IFR and CFR.
And IFR as in individual forest rights and CFR as in community forest rights.
Now, even within this statistics, what if you look at 19 lakhs IFR and 76,000 odd CFR, you find there is uneven implementation. Out of those 19 lakh individual forest rights claims recognized so far, 71% of recognized claims belong to these 5 states: Tripura, Maharashtra, Odisha, Madhya Pradesh, and Chhattisgarh. Similarly, if you look at the statistics for community forest rights, 87% of community forest rights are recognized in Maharashtra, Chhattisgarh, Madhya Pradesh, Odisha, and Gujarat. Okay? So there is uneven implementation. Second, overall, if you look at 96% of recognized claims in the country are individual forest rights. Only 4% of recognized claims are community forest rights. Third, around 99% of claims are for tribal communities, whereas you have less than 1% claims for other traditional forest dwellers in the country.
Right. And OTFT refers to other traditional forest dwellers, people who may not belong to scheduled tribes but have been residing on forest land for 3 or more generations before 2005.
Take the case of Odisha, which has recognized around 4 lakhs of individual forest rights claims in the state, but only 73 claims are for OTFDs. So many of the states have not recognized the rights of OTFDs. And that is another problem. And fourth, most of the states, including these leading states, whether it is Maharashtra, Odisha, recognition of rights in protected areas has been very, very low. Okay, you have exceptional, cases like the BRT hills in Karnataka, where the rights of Soliga tribes have been recognized in the Tiger Reserve area. Otherwise, there are, hundreds of protected areas where you find no rights have been recognized so far. And another important challenge in the implementation process, what we see, that many cases you find people's rights over land and resources have not been discussed and rejected in an arbitrary manner without following the due process. And that is what the ongoing case in the Supreme Court is also about, where the Supreme Court has given a stay order not to evict people unless the procedure is followed as per the Act. These are several challenges at the implementation level. Uneven implementation. Priority is on IFR, OTFD rights are not recognized. Rights are not recognized in protected areas. Claims are rejected in an arbitrary manner without following the due process. And then also you have other dimensions. If you look at the forest rights implementation process, where most of these claims which have been recognized, what you call about IFR and CFR, there is a huge gap between the claimed area and recognized area. For individual forest rights, the law specifies that households can claim up to 4 hectares, but nowhere you find households have been, recognized 4 hectares. Our own study, even national average for individual forest right is 2.15 acre.
That's less than a hectare. So clearly, there are multiple shortcomings at several stages. Could we maybe walk through some of the major reasons behind the poor implementation of the FRA?
The most important factor, I would say, in the poor implementation of FRA has been the role of a nodal agency. So the nodal agency, the tribal department, has not been assertive as it should have been because of various reasons. Because this is a federal law going to be implemented at the state level and further at the local level. So the nodal agency, the tribal ministry and its machinery should have been more assertive, which we see over the last 13 years. The efforts of tribal department to enforce the Forest Rights Act has not been very, very impressive. The second important challenge is at the state level. As I said, it is a federal law to be implemented by the state and local bodies. At the state level, you have several managerial as well as technical challenges to implement FRA, in addition to commitment and coordination at the district level. When I say managerial and technical skills, many of these officers who are supposed to implement FRA at the DLC level, at the SDLC level, they have not been trained about the process of FRA. And wherever the training programs have been conducted, what generally happens, they are transferred after 1 year or 2 years, and the whole process gets affected. And the third important dimension at the state level is coordination among these three important departments: forest department, revenue department, and tribal department. These are the three departments which are very, very crucial and central to the implementation of FRA at the district level, at the subdivision level. Unfortunately, coordination is not happening. Meetings are not happening regularly. Title claims are pending for so many years. There is no accountability and liability fixed. So as a result of which, what we witness, the process of FR implementation, whatever we have witnessed based on our empirical work and various other institutes in the country have come out, that process has been driven by NGOs and grassroots organizations. But there are limitations for their involvement because of resource, time, and the scale and form of implementation requires consistency, which the state agencies could have done a better job. And our own study also shows during election time, the title distribution goes up, and after election, the title distribution comes in. And in some cases, even titles have been withdrawn after election. So this clearly shows how FRA process of implementation has not been taken seriously, both by political leaders as well as administration.
Yes. And before we get into locating the role of NGOs and civil society members, can we delve into some state-specific approaches? We've already started talking about the differences in effectiveness across different states. So maybe this would be a good time to learn from certain states that have performed relatively better than others in implementing the FRA.
Right. There are states like Maharashtra and some parts in Odisha and Gujarat. We see how FRA has been implemented, and you see a better picture in comparison to other states. Okay. And there are several reasons for this state of affairs, especially in case of Maharashtra. Okay, if you look at the overall statistics comparing Maharashtra's process of implementation of FRA vis-a-vis other states and at the national level, what you find, 10% of recognized claims, especially community forest rights in the country, come from Maharashtra. While the national average for community forest rights in the country, you see, is 115 acres. In Maharashtra, it is 372 acres for community forest rights claim. While at the national level, the rights of OTFD communities have not been recognized, but in Maharashtra, both for IFR and CFR, you see around 16,000 OTFD claims over individual forest rights and around 2,300 odd community forest rights claims of OTFDs have been recognized. But most important part of Maharashtra FR story is the outcome of the implementation process. So this is the only state at present in the country which has deregulated the minor forest produce rules and regulations. Okay, we discussed in the beginning that how in early 50s and 60s all states nationalized, regulated their minor forest produce. But FRA recognizes exclusive rights of community over minor forest produce under section 31C. But not all states are deregulating the minor forest produce. Okay, so Maharashtra became the first state to deregulate, and it empowers the local community to decide where they want to sell, how they want to sell, what should be the price for that. Many examples you have where tribal groups, with the help of forest rights groups and NGOs, have asserted their rights over minor forest produce. Second important development that we see in Maharashtra is the institutional support from government departments, especially the tribal development department, and support coming from the governor office in Maharashtra. Our own study shows there are 87 enabling orders have been passed by the state of Maharashtra. Both tribal development department, governor office played a significant role in notifying, issuing orders, and these orders are related to formation of forest rights committees, about deregulation of minor forest produce, management of forest resources with local NGOs, participation by line departments, appointment of forest rights coordinators. So there are more than 100 FRA coordinators in the state, and these are the coordinators which facilitate between Gram Sabha and district administration. Similarly, you have PESA coordinators.
Right, that's as per the provisions of the Panchayat Extension to Scheduled Areas Act.
Like FRA coordinators, there are PESA coordinators who are involved in facilitating various issues, including forest rights and land issues in the fifth scheduled areas in Maharashtra. And then you have a district level convergence committee, where all the line department schemes and programs are converged to support the forest rights holders whose rights have been recognized either for individual forest rights or community forest rights, so that the recognized rights over land can be more productive. Their livelihood can be enhanced. So these are institutional support which we see in many other states they are lacking for various reasons. And one important factor has been the active and consistent role played by grassroots organizations and forest rights groups in the state. What I have seen in my own study in Maharashtra vis-a-vis other states, here you have groups and forest rights community organizations who are not afraid to confront with the state, who are also not afraid to collaborate with the state, and also to file litigations. So confrontation, cooperation, and litigation, these are the strategies which have been employed by forest rights groups in the state to advance and promote the interest of tribal communities.
Right. That helps to understand some of the pressures that are pushing the bureaucracy and elected officials to implement this act fairly. I know that some of your research also delves specifically on the role that civil society organizations plays, and I was curious if there were other insights you'd like to share about the factors that could help secure land and forest rights for Adivasi and forest-dwelling communities.
So if you look at the implementation process, which involves claim process, involves recognition process, as well as involvement in the post-recognition phase. In all three phases, you find the role of NGOs and civil society groups across the country has been very, very significant and crucial. Now, in the claim process, if you look at the role of NGO or civil society groups here, it involves not only training and creating awareness about Forest Rights Act, but also empowering them so that they can be the decision makers. Okay. So if you empower the local community, then even if you exit from the process, they can take that process to next level. Okay, and this is very important. The kind of strategy that is followed here, it is not a kind of complete overtaking the process of claim filing, rather training them, empowering them to understand the process as well as the provisions in the act. So that is an important contribution, I would say. The process of intervention doesn't stop with filing claims. It continues till they get a title. So the continuous follow-up is an important lesson that one can learn from Maharashtra. How after claim filing, you need to follow up with the SDLC and DLC level. What is the status of the claim? What kinds of documents are required? Why it is pending? For what reason? So this is very important for various other groups in the country to follow up. And we have done studies in other states also. We find many NGOs and groups are not following up once claims are filed. The focus is more on number, not on the quality of implementation. When you focus on number, not on the quality of implementation, then you find there is a gap between claimed area and recognized area. There is delay in recognition. And then also many cases, the claims are rejected without explanation, and there is nobody to question that administration. And this is possible when one consistently follows with the administration or with the authorities. And third dimension is once rights are recognized, because many of these areas, as per the statistics shared by Minister of Tribal Affairs, there are infrastructure gaps in tribal areas. Whether it is irrigation facility, whether it is electricity, whether it is extension service by the departments are not reaching to tribal villages or these forest dwelling communities. Because once rights are recognized, you need to make those lands productive. And there you need institutional support, there you need extension service, there you need training, there you need irrigation facilities, line department schemes and programs. And this is where the NGOs in Maharashtra, after recognition, they started intervening in the post-recognition phase. And Section 16 of the Act emphasizes that the state government shall make efforts to integrate line department schemes and programs with forest rights holders. And this is what they demanded. And today you have more than 300 villages in the Maharashtra where we see the Tribal Development Department has given them grant to implement a Forest Rights Act, especially to prepare the Community Forest Rights Management Plan.
Mm-hmm. Mm-hmm. And the next and last question is a little more forward-looking, and it's a question that we like to ask all our guests and end on, is what will it take to secure land rights for 1 billion going forward?
Right. You cannot have a nationwide generalization of public policy or legislation. And that's why today we are facing challenges in many parts in the country when it comes to FRA. The total area that needs to be recognized. What should be the institutional mechanism to provide support to the recognized forest rights? When you talk about self-governance by Gram Sabha, it may not be a kind of a scientific idea unless you provide extension service, unless you provide technical managerial skills to the Gram Sabhas. So I think that is one important policy change required, as well as a change in the philosophy of both forest rights group and wildlife groups in the country, where we need to see the limitation and potential of state as well as Gram Sabhas. Only then we can strengthen the process. Because the Gram Sabhas have huge potential. They have traditional and customary, knowledge. They have been protecting the forest for centuries, and you have best examples in front of you. States like Uttarakhand, Odisha, Maharashtra, where communities have protected forests and have shown excellent results comparison to protection and management of forests by state machinery. Similarly, the potential of state machinery, because state is very, very important when it comes to resource supply, when it comes to technical knowledge. And this is possible because we are talking about 70 million hectares of forest in the country. So it is practically not possible to manage such huge forests without resource, without technical knowledge and support. And third important dimension is policy intervention. I was talking about is recognizing the importance of institutions, both formal and informal institutions. As I said, there are limitations at the Gram Sabha level as well as at the department level. So we need to recognize limitations and enhance the livelihood of local community as well as the forest conservation activity by recognizing the potential of both state and Gram Sabhas. So that will be an important area of intervention in future where we recognize the limitation and potential of both Gram Sabha and department.
Thank you so much for joining us on Land of a Billion, Professor Sahu. We covered a lot of ground today, and you've provided us with a solid crash course on the FRA and land rights.
Thank you so much. Thank you.
I hope you enjoyed that conversation, and I'm really looking forward to bringing you another episode of Land of a Billion in 2 weeks. To make sure you don't miss out on it, do subscribe to us wherever you get your podcast from. Also, we'd love to hear from you about this podcast and what's working for you and what isn't. Do tweet or send us a message at PRRC_India on Twitter. And if you like our work, do consider sharing it. Take care, and I'll see you in 2 weeks.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.